Praveen's Notes on Doctrine of Election. Section 35 of Transfer of Property Act 1882 incorporates the doctrine of election. Election means choosing between two inconsistent or alternative rights. Under any instrument, if two rights are conferred on a person in such that one right is in lieu of the other, he is bound to elect only one of them. The doctrine of election, which is based on equity, is applied to every species of instrument, whether deed or will, and to every kind of property, movable or immovable. Election is the obligation imposed upon, as a party by courts of equity, to choose between two inconsistent or alternative rights and claims in cases where there is clear intention that he should not enjoy both. Section 35 of the Act makes following provisions in respect of the rule of election. Where a person professes to transfer a property not his own, in lieu of this transfer, the transferor confers certain benefits upon the owner of the property, and the two things, i.e., transfer of property and conferring of the benefit, forms part of the same instrument. Transferor professes to transfer property not his own. Section 35 applies where a person professes to transfer the property of another person. Professes means purports of, makes contract. Since such person is not owner, he cannot transfer that property. But he can contract or make arrangements for a transfer of a property which he does not own. For example, A may profess to transfer of a property to B, which is owned by C, and also confer on C a benefit of ₹1,000. In this contract, A is not transferring C's property. He is simply professing to transfer a property which he does not own. Therefore, A is not transferor. But for the sake of convenience, hereinafter A may be called as a transferor. In lieu of this transfer, the transferor confers certain benefits upon the owner of the property. The occasion for election arises only where a benefit is directly confirmed on the owner of the property. Where benefit is given to the owner otherwise than for transferring property, or is given to him indirectly, there is no case for election. Illustration: A professes to transfer C's property to B and gives Rs 5,000 to wife of C. This is not a direct benefit to C, and therefore, C has no duty to elect. Case law in Valliamme v.S. Nagappa, Cooper v. Copper, 1874, 7 HL.53. A testator purported to bequeath a joint family property to his coparcenor. The coparcenor was otherwise, under Hindu law, entitled to that property. The Supreme Court held that coparcenor cannot be said to have derived any benefit under the will and is not put to election. Transferor has no authority to transfer the property is immaterial for applicability of the rule of election. The rule applies whether the transferor does or does not believe that the property which he is professing to transfer is not his own. Part of the same transaction, the rule of election operates only when the transfer and benefit from part of the same transaction. By same transaction is meant that the transfer of property is to be made evidently only in lieu of the benefit. Thus, where the benefit and transfer are interdependent and inseparable therefrom, part of the same transaction. In Muhammad Afzal v.S. Ghulam Qasim, 1903, 30.call.843, after the death of Nawab of Tank, the government, while transferring chiefship to Nawab's eldest son, transferred some cash allowance to Nawab's second son. The Nawab in his lifetime had already granted 2 villages to the second son for his maintenance. The Privy Council held that since the 2 grants, cash by the government and villages by Nawab himself in his life, came to second son from 2 different sources, they were not part of the same transaction. The second son was not put to election. Owner's duty to elect if a property is professed to be transferred and in the same transaction some benefit is given to the owner of property, then such owner is under a duty to elect. By his election, he may either accept the instrument with its all contents or reject it altogether. He has no option to accept the instrument. He is entitled to get the benefit, but he is bound to transfer his property. If he elects to reject the instrument, he cannot claim benefit, but he may retain his property. Where a person has no act into different capacities. Mode of election: election may express or implied. Where election is expressed, it is final and conclusive. The intention of the owner may also be inferred from his act or conduct. This is an implied election. Presumption: 1. Where the owner has enjoyed the benefit for 2 years without doing any or dissent of the transaction. 2. Where the owner of property exhausts or consumes the benefit. Rights of disappointed transfer. He has the following rights. I. Where the transfer is gratuitous, i.e., without consideration, and the transferor dies or become incapable of making fresh transfer, and 11. Where transfer is with consideration, whether he is alive or dead at the time of election, the transferee is entitled to get a reasonable compensation from the transferor or representative. Reasonable compensation equal to the value of property professed to be transferred. Illustration: the farm of Sultanpur is the property of C, and its market value is Rs. 800. By an instrument, professes to transfer it to B, giving by the same instrument a benefit of Rs. 100 to C. C elects against the transfer and decides to retain his farm. C forfeits the benefit of Rs. 1000, which reverts back to A or his representatives. Now, if A dies before C makes election, his representatives must compensate B, disappointed transferee, by giving B Rs. 800 out of Rs. 1000. English law, English doctrine of election. Under English law, where the election is against the instrument, the benefit does not revert to the transferor, the owner of property. While rejecting the transfer, may insist upon taking also the benefit conferred on him. He is, therefore, called a refractory done or a rebellions done. The owner of property C, while electing against the transfer, would also take the benefit of Rs. 1000, but C would be liable to give Rs. 800 to B, the disappointed transferee. A or his representatives are not liable to compensate B. Difference between Indian doctrine of election and English doctrine of election. Section 35, 1 lays down the principle which differs. First rule: the doctrine under the English law is different from the rule in the section. Under the English law, if the grantee, the owner of the property which is transferred, takes against the instrument, the court of equity assumes jurisdiction over the benefit intended for him under the instrument and gives compensation to those who were disappointed by his election. The surplus, after compensation, does not revert to the donor but is restored to the done. Under the Indian law, the benefit conferred by the instrument reverts to the donor or his representatives, except in the 2 cases specified in the section. The illustrations to Section 182 of the Succession Act furnish additional illustrations of the doctrine. 1. The farm of Sultanpur was the property of C. A bequeathed it to B, giving a legacy of 1000 rupees to C. C has elected to retain his farm in Sultanpur, which is worth 800 rupees. C forfeit his legacy of 1000 rupees, of which 800 rupees goes to B, and the remaining 200 rupees fall into the residuary bequest, or devolve according to the rule of intestate succession as the case may be. 2. A person of the age of 18, domiciled in India, but owning real property in England, to which C is heir at law, bequeathed a legacy to C, and subject thereto, devises and bequeaths to be all in property whatsoever, and wheresoever, and dies under 21. The real property in England does not pass by the will. C may claim his legacy without giving up the real property in England. The reason for this rule under Indian law is that the transfer of the benefit to the owner is regarded as a conditional transfer. Hansbury, in his Equity, thinks the Indian rule is the better rule based on the principle of compensation. Suspension of election, where at the time of transfer, the elector, i.e., owner property, is legally disabled, the election is postponed until such disability ceases or until an election is made on his behalf by a competent authority, e.g., his guardian. Legal disability may minority or lunacy of the elector. Thus, his duty to elect is suspended during his minority or luna unless the election is made by his legal guardian. Exception under his is entitled, if she survives to the enjoyment rupees her life, lieu interest in the estate of Sultanpur, which estate he bequeaths his son. He also gives wife a legacy of 1,000 rupees. The widow elects to take she entitled to under the settlement. She is bound to relinquish annuity, but the legacy is 1,000 rupees. Hindu A. Bequeath, which was the provision maintenance, was in lieu her husband's property. She filed against B decree for her maintenance. Hereafter, she filed a second suit to share her husband's property. It was held that the second suit was not maintainable because she had elected to take maintenance. Knowledge, the elect, and an actual election distinct things. Suppose A. accepted from for years, but C was not aware terms the lease between, and B in such case, C could not have elected to confirm the lease. Similarly, the 1-year rule in the section is also not found in English law where there is no time limit time. Prescribed time limit. Another difference between the two system laws, while English if the person asked to signify does not so, will be treated as he elected against the instrument, India, deemed to confirm the transfer in similar circumstances.